I want you to run a little simulation in your head for a second. It is going to get a little dark, so just bear with me, but I promise there is a point.
Okay.
Imagine something happens to you tomorrow. Not in 20 years. Tomorrow. You step off the curb, or you have a sudden medical event, and just like that, lights out. You're gone.
It's the scenario literally nobody wants to visualize. I mean, we are wired to avoid thinking about it.
Right. But keep the simulation running.
Mm.
Look at the people you've left behind. Your spouse, your kids, maybe a business partner.
Mm-hmm.
Here's the question I want you to answer honestly. Would those people spend the next 2 years and roughly $100,000 in court battling strangers just to get permission to access the life you built?
It sounds like, I don't know, the plot of a dystopian novel. But for about 20,000 families in Arizona right now, that isn't a simulation. That's just their Tuesday morning.
20,000 active cases. That number just blew my mind.
Yeah.
Welcome back to the Deep Dive. Today we are unpacking a seminar from a group called Claim My Legacy. And I have to be honest with you, when I first saw the deck for this, I thought, okay, estate planning, this is going to be dry, this is going to be like eating sawdust.
It's usually the cure for insomnia. Yeah.
Exactly. But this material, it's genuinely terrifying.
Yeah.
But it's also, it's like finding a cheat code for the legal system.
I agree.
We're going to unpack this probate trap, why the will you have sitting in your desk right now might actually be a liability, and the mechanics of a revocable living trust.
And I think the reason this specific material hits so hard is that it attacks that I'm good fallacy. You know, most of us, we think, I have a job, I have a house, I wrote a will, I checked the box.
That is the conventional wisdom. I have a will, so I'm safe. But the source material comes out swinging with a pretty aggressive counterpoint. It argues that a will is actually designed for the court system.
Yes.
It isn't a void court card. It's basically an invitation to court.
That is the single biggest aha moment in this entire stack of research.
Yeah.
I mean, think about what a will physically is. It's a letter. It's a letter to a judge.
To a judge.
It says, "Dear Judge, now that I'm dead, please give my stuff to these people." But a letter doesn't move money. A letter can't sign a deed.
Right. It needs a human being with a gavel to make it real.
Precisely. And that validation process is what we call probate.
So let's deep dive into probate, because the word gets thrown around, oh, it's in probate, but I don't think people realize the mechanics of it. The source describes it as a trap. What is physically happening?
At its core, probate is a lawsuit. It's a lawsuit you file against yourself, funded by your own money, to prove who owns your assets because you're not there to speak for them.
Wait, hold on. A lawsuit against yourself, that sounds absurd.
It does, but think about the legal reality. If you own a house, your name is on the deed. If you die, that house is now owned by a ghost. No one can sign the deed to sell it.
It's just stuck.
It's legally frozen in limbo. The only person on earth who can unfreeze it is a probate judge. So you have to sue the estate to get the judge to transfer the title.
And the source material is absolutely brutal on the costs of getting that judge involved. It mentions Arizona specifically, but I assume this applies everywhere.
It varies by state, but the principles are the same. And the math in this Arizona example is painful. Between executor fees, attorney fees, court costs, the system sucks up anywhere from 6 to 22% of the gross estate value.
Whoa, hang on. 22%. That's nearly a quarter of everything you own.
On the high end, yeah.
So let's just do the napkin math here, because I want to make sure I'm getting this. If you're the typical middle-class family, you own a home, maybe a 401k, let's say it totals $500,000.
Yeah, very standard.
So we're talking about potentially $100,000 just vaporized.
Gone. It goes to pay the attorney, the appraiser, the court. It doesn't go to your kids. It doesn't go to your spouse. It just feeds the bureaucracy.
That is shocking. I mean, money is one thing, but the time aspect, they call it jail for your money. That felt even more stressful to me.
That is the part that destroys families. The average probate case in this data set drags on for 1 to 3 years.
3 years?
Easily. And during that time, assets are often frozen. So imagine, your family is grieving. The mortgage is due next week. The tuition bill is due next month. There's plenty of money in the bank.
You can't touch it.
The bank manager says, "I'm sorry, the account is frozen until a court order comes through."
That isn't just inconvenient, that's ruinous. You could literally lose the house while waiting for permission to inherit the house.
It happens, and we have a specific case study in the notes that illustrates this perfectly. The story of Sarah.
Yeah, this one was heavy. Walk us through Sarah's situation, because she did what she thought was right.
She did. Sarah was a single mom with 2 teenagers. She was responsible. She had a will. She had a house worth about $450,000 and some savings. She passes away unexpectedly.
And because she had a will, she thought, my kids are taken care of.
Right. But remember, the will is just a letter to the judge.
Mm-hmm.
So the estate goes into probate. The court freezes everything.
Yeah. And the kids.
The kids were stuck in the system for 2 years. In those 2 years, they couldn't access cash for college, so they missed semesters. By the time the dust settled, the fees had eaten $92,000 of their inheritance.
$92,000. That is a college education right there. Poof.
It is. The source quotes the kids saying they felt like their mother's legacy was stolen by the system. And the tragedy is Sarah meant to fix it. She had set up a trust on her to-do list. She just put it off.
Later. The most dangerous word in the English language.
In estate planning, later is almost always too late.
There's another layer to this probate nightmare that I think people underestimate. We think of our finances as private. But probate is a court proceeding.
Which means it is public record.
Fully public, like I could go look it up.
Anyone with an internet connection can pull the file. They can see who died, what they owned, who the beneficiaries are, and exactly how much they're getting. It's basically a shopping list for scammers.
That is so creepy. But the source material takes the creep factor to an 11 with the audit.
The inventory and appraisement.
Yeah, this part gave me the actual chills. Describe what happens here.
So the court needs to know the value of the estate to calculate its fees, right? In many cases, this involves a court-appointed stranger, an auditor, literally walking into your home.
While your family is grieving?
While they are grieving, this stranger is opening drawers, looking in closets, counting the silverware. They are inventorying your life. They are touching your things.
It feels like such a violation.
It is. It's the ultimate invasion of privacy at the worst possible moment, and it's standard procedure in probate.
Okay, so we've established that probate is expensive, public, and slow. But there's a scenario in the source that is even worse than Sarah's. Sarah at least had a will. Let's talk about Tom and Sheila.
This is the nightmare scenario for unmarried partners, and frankly, for anyone living together without a marriage certificate.
And this feels like a movie script, but the source says this happens all the time.
Constantly. So Tom owns a successful hardware store. He's done well. Beautiful home worth $2.8 million. He's 48, healthy, living his best life.
And he lives with Sheila.
His partner of 25 years. But, and this is the crucial detail, they never got married. And the house, the business, the cars, all in Tom's name.
Which, when you're alive and happy, doesn't really matter. What's mine is yours.
Exactly. They had talked about setting up a trust. It was Christmas. Tom says, we're busy. We'll do it after Christmas. Then January comes. We'll do it after Valentine's.
And then March hits.
Tom dies in a car crash. No will, no trust, no plan.
So legally, what happens to Sheila? She's lived in that house for a quarter of a century. It's her home.
Legally, she's a stranger.
Oh.
Since she isn't on the deed and there's no marriage, the state's intestacy laws kick in. The assets go to Tom's next of kin, maybe a distant sibling he hasn't spoken to in years.
And Sheila gets evicted.
Evicted from her own home. She has zero claim to it. She leaves with whatever she can carry.
That's devastating. But the damage didn't stop at the house. The hardware store. This is the point I want to drill down on, the business impact.
This is technical but so vital. A business is an active entity. It has payroll. It has suppliers. Who was the signer on the bank account?
Tom.
Only Tom. So, Tom dies. The bank freezes the business accounts immediately. Payroll is due on Friday. Sheila can't sign the checks. The manager can't sign the checks.
So the employees don't get paid?
Employees walk. Suppliers stop shipping. A multi-generational family business, something that took decades to build, effectively imploded in 2 weeks.
All because of a missing signature.
All because Tom thought he had time.
That really drives it home. It isn't just about who gets the china cabinet. It is about the continuity of life.
Exactly.
Okay, I think we have terrified everyone sufficiently. The probate trap is real. Relying on a will is risky. Doing nothing is catastrophic. The source material is pushing heavily for the revocable living trust.
The solution?
So help us pivot here. How is a trust different? The source uses this safe analogy, which I liked, but I want to make sure we really get the mechanics, because trust sounds like something only Rockefeller kids have.
It's a common misconception, but it's for everyone.
Yeah.
The analogy is great. Think of a revocable living trust as a bulletproof safe that you buy while you're alive.
Okay, I have a safe.
Now, here's the key step. You have to fund the trust. You have to take your assets, your house title, your bank accounts, and literally change the name on them from John Doe to the John Doe Family Trust.
Yeah.
You put them inside the safe.
So the safe now owns the house. But I'm still alive. Can I sell the house? Can I spend the money?
Yes, because you hold the key. You are the trustee. You can put things in, take things out, spend the money, buy a boat. Your day-to-day life changes 0%.
So control is total. I'm not locking myself out of my own money.
Total control. But here's the magic trick. When you pass away,
I drop the key.
you drop the key. But you've already written down exactly who picks it up. That's your successor trustee. Maybe it's your adult daughter.
And do they have to go to a judge to ask for permission to use the key?
0 judges. 0 courts. They pick up the key, open the safe, and follow the instructions you left inside.
So it's private.
Completely private. Nobody knows what was in the safe except the family.
And it is fast.
Immediate. The source contrasts the Tom tragedy with the story of Mike and Lisa. Mike had a trust. When he passed, his son was the trustee. He walked into the bank with the trust document and a death certificate.
And that was it.
The bank manager said, "Okay, you're the new signer." He could pay the funeral costs and distribute the inheritance within weeks.
That seems incredibly civilized compared to the alternative.
It is the difference between chaos and order.
Now, there was a term in the notes that sounded a bit ominous initially, rule from the grave.
Yeah.
But as I read it, it actually sounded like parenting.
It's essentially protective parenting. Look, if you leave money via a will, it is usually a lump sum. Here's 500 grand, good luck.
Which, if your heir is 21 and likes fast cars.
Is a recipe for a very fast disaster. With a trust, you can set conditions. You can say you get the money in monthly installments, or you get matched dollar for what you earn.
Oh, I like that. The incentive trust.
Exactly. But the most critical application of this is special needs planning.
Right, this is huge for some listeners.
If you have a child with a disability who relies on government benefits, Medicaid, SSI, and you dump a lump sum of money on them, what happens?
They lose their benefits because they have too many assets.
Instantly disqualified. A trust can be structured so the trustee holds the money and pays for things the government doesn't cover. Better wheelchairs, therapy, travel, without the child ever technically owning the money.
So you improve their life without kicking them off the system.
Precisely. You can't do that with a simple will.
It seems like the trust is just a much more sophisticated tool. A will is a hammer, a trust is a scalpel.
That's a fair comparison. And we haven't even talked about the biggest risk yet. We've been focused on death. But the source makes a compelling argument that incapacity is actually the messier problem.
Yeah, this shifted my perspective. Death is final. But what if you have a stroke? Or get dementia? You're physically here, but you can't sign your name.
This is where the will completely fails you. A will only works when you're dead. It does nothing for you while you're incapacitated.
The source brought up the Terry Schiavo case. I remember that from the news. It was everywhere.
It was tragic. 15 years in a vegetative state. She had no living will, no instructions. Her husband and her parents fought a brutal war in court over what to do.
It tore the family apart publicly.
And let's look at a more common scenario, dementia. The source tells a story about a woman whose husband had Alzheimer's.
This is the conservatorship nightmare.
Right, they've been married 40 years. Joint assets. But he started wandering, didn't recognize her. She needed to access their retirement savings to pay for a care facility. But because his name was on the accounts,
She was locked out of her own money.
locked out, she had to go to court and apply for conservatorship. Basically, she had to sue her husband to get control of their money.
And the source mentioned the humiliation of that.
She had to report every penny she spent to a court auditor. Can I buy groceries? Can I pay the electric bill? Imagine having to beg a stranger for permission to use the money you saved for 40 years.
It's stripping away your dignity.
It is, and a trust prevents this entirely.
Because the trustee just steps in?
Yes. If you have a trust, it defines incapacity. If you can't act, your successor trustee, your spouse, your kid steps in immediately. No court, no public reporting. It stays in the family.
So the source outlines a toolkit. It isn't just a trust, right?
Correct. The trust is the safe. But the toolkit has 4 pillars. You have the revocable living trust for asset control, then a financial power of attorney for non-trust assets,
Okay.
then the medical power of attorney, which says who makes health decisions, and finally, the living will for your specific end-of-life instructions.
It's a comprehensive shield. It covers the money, the health, and the legacy.
It closes all the gaps.
So let's get down to brass tacks. The source material is a seminar, so they are pitching a service. But they break down the math, and it is hard to argue with the ROI here.
It's a pretty stark cost-benefit analysis. The source mentions a comprehensive package like this typically costs around $1,800 with their seminar discount.
$1,800 versus potentially $100,000 in probate fees.
And years of time and the emotional toll.
You know, I forgot to mention the grandfather story from the source. This really highlighted why wills are so fragile.
Oh, the host's grandfather. Yes. That was
Yeah.
a perfect example of family dynamics gone wrong.
He had a will. He had 14 children.
14. That is a lot of potential opinions.
And just one uncle had a petty disagreement. He contested the will.
And that's the thing. You can contest a will very cheaply. You just file an objection and throw a wrench in the gears.
And that one contest dragged the estate out for 2 years, cost tens of thousands in legal fees, and it permanently fractured the family.
And that's a reality. You might think, my kids get along great, but grief and money do weird things to people.
A trust is harder to break.
Much harder. A will is a request. A trust is a contract. It locks the door on that kind of casual infighting.
So essentially, for the price of a decent laptop, you are buying an insurance policy against your family falling apart.
You're buying peace.
The source ends with a really provocative question, and I want to pose it to our listeners. If something happened tomorrow, would your family be okay?
It's the question we all avoid. We all think we have time. Tom thought he had time until after Valentine's Day. Sarah thought she'd fix it later.
But later is not a calendar date.
It isn't. And I think what this deep dive really reveals is that estate planning isn't about death. We frame it that way, but it's actually about life. It's about ensuring that the people you love continue to live the life you wanted for them.
It is true. When you look at the Mike and Lisa story, the family with the trust, the kids felt loved. They felt protected. They didn't feel like the system robbed them.
And that's the ultimate value. You're making sure that your passing is a time for grief and remembrance, not a time for paperwork and auditors in your closet.
I keep going back to that image of the stranger going through the drawers. The audit. That alone is enough motivation for me.
It should be. The source mentioned they've helped over 20,000 families, but there are millions who are just rolling the dice on the default settings.
And the default setting is the state takes control.
Exactly. If you don't have a plan, the state has one for you, and you won't like it.
So here's the final thought. We've talked about the mechanics, the dollars, the courts, but I want to leave you with something a bit bigger.
I would ask the listener to consider this. When you look at everything you've built, your home, your savings, do you view estate planning as a financial transaction, or is it actually the final act of parenting?
That hits deep.
Is it the last way you protect the people you love from a world that doesn't care about them the way you do? Because if you view it as protection, the cost becomes irrelevant and the urgency becomes real.
That's a powerful framework. It isn't about the paperwork. It is about the people.
Yeah.
Thank you for walking us through this. It's definitely given me a kick in the pants regarding my own someday plans.
My pleasure. It is the most important homework assignment you'll ever have.
And thanks to you for listening. We'll catch you on the next deep dive. Stay curious and maybe, just maybe, go build your family safe.